Hello, everyone, and welcome to the Legal Studies Guy as we get very, very close to the end of Area of Study 1 of Unit 3, as we're up to knowledge dot point number 12. Our quote for today comes from Gandhi, and it is a very famous quote that I'm sure most of us have been exposed to before. And it is the idea that an eye for an eye only ends up making the whole world blind. Why is this important right now? Because, as I said, we are near the end of Area of Study 1. There are only 2 more videos to go after this, and then you will have your SAC for Area of Study 1. Now, if you are like my school, this will have been most likely broken into 2 SACs, but generally that first one's a little bit smaller. So you're probably about 2 weeks out from a considerable SAC. And yeah, I suppose the idea of the fact that you're stressed, your classmates are stressed, other students in the school have probably got assessments as well that they're stressed for. This idea that don't treat each other with cruelness, it will only breed more cruelness. Remember to treat each other with love and compassion and support during this part of the year, and for the rest of the year, obviously. As mentioned at the start, we are at dot point 12. And here we are looking at a new piece of content that is new to this study design and was not included in the old study design at all, not even at year 11 level. And these are factors considered in sentencing, including. So we are just looking at factors considered in sentencing. So that's the sort of question we can expect, or the language you can expect in a question. You know, hey, here's a case study, a scenario, what sort of factors were considered here, but particularly including aggravating, mitigating factors, guilty pleas, and victim impact statements, which we might have heard of or know a little bit about already. So we'll explore each of these 4 things that we specifically need to know as per the study design. This will be quite a short video. It's basically just getting some knowledge in your head, because as we can see from the skills, there's no key skill linked to these in terms of we don't have to explain any of them or discuss any of them or anything like that. So from my understanding of that, and we'll talk about it a little bit later on, I think it will be purely geared towards that key skill dot point 11. As we go back one, which is, I can't control my screen, which is basically case studies. So, you know, the whole idea of what factors might have been considered here. Our essential question that we'll be able to answer at the end is, what factors will a judge consider in sentencing? So, as I mentioned there, in that last slide, there are 4 factors that are clearly listed in the study design. So the idea of these factors is that every crime isn't created equal. And to go further, obviously we know that, like, murder is worse than assault is perhaps worse than theft is perhaps worse than a driving offence. We know that already. But then within that, within each individual crime is not created equal. So not every theft is created equal. There are some thefts that are more serious than others. Not every murder is even created equally. There are some murders that are significantly worse than others. So every crime itself has, I suppose, a scale of seriousness, and there are lots of factors that the judge will then consider when they are sentencing the offender for committing one of these crimes. That being, you know, how serious of a sanction are they going to lay down? You know, will they send someone to prison, or will they give them a community corrections order? So on and so forth. The 4 factors that they'll consider are there any aggravating factors? So these are aspects of the crime that make it worse, okay, that increase the culpability of the offender. In contrast to this, they will also consider mitigating factors, so number 2, and these are again about the culpability of the offender, but factors that reduce or decrease the culpability. So we're going to look at some examples of those in a minute, but, you know, something that increases your culpability and culpability meaning how much blame you should take. Things that increase your culpability are things like premeditation, so that you planned it out in advance. Mitigating factors, things that reduce your culpability or decrease it, are perhaps personal circumstances that led to your offending, that mean you are less in control of your actions than perhaps other people. We also will look at guilty pleas, so how a judge will consider a guilty plea when they're sentencing, and the guilty plea will usually lead to a decrease in sentence for a number of reasons, which we'll look at. And then also the impact of, good use of words there, Dan, the impact of victim impact statements. So what level of, I suppose, emphasis a judge will place on how much impact an offender's crime had on a victim, and that could be, hey, you know what, this is going to affect me for the next 20 years due to perhaps some injuries sustained or some the mental effects of and the stress and the post-traumatic stress disorder caused by a crime, and therefore a judge might want to give someone a more, I suppose, a lengthier or a more extreme sanction to, I suppose, get retribution for that victim. So we'll look at that in a little bit more detail. So, aggravating factors, and I'm sure many of you will have seen this meme before that I'm using on the right, and I'll get to that in a moment. So, as I said with aggravating factors, it's all about things that increase culpability. And again, culpability is level of blame. So what things will the judge look at that will increase the level of blame a person should take for their actions? And they are things like premeditation. So the idea that you didn't just randomly see an opportunity and think, oh, I'm going to do that without really thinking. The fact that you had planned it out in advance, you had made a conscious choice that this was a crime you were going to commit. The use of a weapon is something that is an aggravating factor, because naturally if you involve a weapon in your crime, you are therefore more likely to cause serious injury to someone, and therefore your level of culpability is increased and you deserve a tougher sanction. Another aggravating factor, and which is why I have included this image, because as you know in the meme, he is with another girl over here. And he is obviously looking at another girl whilst walking along with his girlfriend. This is a very clear breach of trust. And that is another key consideration that a judge will take into account when they're sentencing someone. So have you breached someone's trust with your crime? An example of a breach of trust would be, say, if you are the carer for someone, so your job is to sort of give them day-to-day care. Perhaps they're suffering from a serious illness or a disability. And whilst you're caring for that person, you might be selling some of their property on the side to make money, or you might be just using their bank account to buy yourself things, etc. That would obviously be theft, but you would have increased culpability because you would breach the trust of a person that relied on you. Breach of trust is also an aggravating factor in any serious sort of sexual assault cases, particularly in child sex offences as well, because there's usually breaches of trust involved, and that increases the level of blame a person should take, and therefore will increase their sanction or sentence. So increase their sanction from perhaps a community corrections order to a prison sentence, or increase their sentence itself, so from 2 years in prison to 4 years in prison, etc. So that's what aggravating factors do. In contrast to this, you have mitigating factors, so things that reduce the level of culpability. Okay, so reduce level of blame. Okay. Basically, mitigating factors will therefore decrease your sanction or sentence. So maybe if there are a range of mitigating factors, you might get a community corrections order instead of a prison term, or you might get 2 years in prison instead of 4. So the opposite of what aggravating factors do. Personal circumstances such as your age and your background will be considered mitigating factors. For example, a 15-year-old has a lower level of blame, a lower level of culpability than a 45-year-old, based purely on the fact that a 15-year-old is still developing, still learning, and they have a reduced understanding of what is right and what is wrong. If you demonstrate remorse and if you cooperate with authorities in terms of interviews, it's kind of like early guilty pleas, which we'll get to, but you basically help authorities out with their investigation. You will that will be considered a mitigating factor because it shows that you already understand that what you've done is wrong, and therefore a sanction can be applied for other purposes. Other personal circumstances that might be mitigating factors would be things like perhaps a drug addiction, and it's not a great mitigating factor because you've made your own choices there as well, but committing offences under the influence of drugs can definitely influence the type of sanction you're given, because it's sort of acknowledged that you might not have been in the frame of mind. It's not the sort of offence you'd commit if you were in the right frame of mind, and can therefore alter the sanction or sentence you were given. So you've got aggravating factors which increase your level of blame, and then you've got mitigating factors which reduce your level of blame. Another factor that a judge will consider is your plea, and particularly guilty pleas are obviously very important here. And we have a picture of a very, very, very guilty-looking dog who is chewing up a shoe of some kind. I am lucky in my household. My dog tends to only chew up my girlfriend's shoes, so he obviously doesn't like the smell of my feet. But a guilty plea is very, very likely, I'd say extremely likely, to lead to a reduction in sanction. So if you plead guilty at the earliest possible opportunity, you are more likely to get a fine or a community corrections order than being sent to prison. But if the sanction remains the same as it says there, so if you'd still go to prison even if you plead guilty, it is likely that your sanction will at least be reduced. So the idea being that, if you plead guilty to drug trafficking and you would have got 20 years in prison, you might get that reduced down to 16. Okay. The Sentencing Act 1991, this is the document that lists the 5 purposes of sanctions. So we've seen it before. It is the document that is the pure, the very important guideline for how judges should sentence someone. It says in it that if you plead guilty, you should have your sentence reduced by between 20 and 30%. So that's if, hey, you're still going to go to prison. We would have sent you to prison for 10 years. You pled guilty. We'll reduce it by 30%. So you're only going to prison for 7 years. And the judge will explain this in their sentencing remarks. This is because a guilty plea indicates remorse. It indicates acceptance of responsibility. But a real key element of this is that just pleading guilty saves the court time, saves the court money. They don't need to pay a jury to sit on that case if it's an indictable offence. They don't need to, schedule you in for 2 weeks of hearing, 2 weeks of a trial, because means they can put in another trial. But it importantly, and we'll see some sentencing remarks later on from Tasmania, it saves causing harm to a victim in the sense of they will not have to come into the courtroom to give their evidence and relive the harm that occurred to them if it is a crime that has a victim. Speaking of crimes that have a victim is our 4th factor that a judge will consider, and they are victim impact statements. Okay? So if a crime has a victim, which most or a lot of crimes do, the victim will be able to write up a statement that outlines how the crime has affected their life. This is pretty freeform. It could be a written statement, it could be typed up, it could be done very formally. It can be done in terms of pictures, drawings as well. A victim can come in and read out their victim impact statement as well. So it's very accommodating in terms of allowing victims access to the criminal justice system, which is a very important principle of justice, as we know. As you can see, we've got 2 victims here in this image. So I'm assuming these fellows have been a victim of some form of crime, perhaps an assault by the look of it. What might happen is, let's just say this fellow here, obviously here he's got a bloodied nose, but we find out later on that he needs facial surgery, and that due to the impact on his nasal cavity that he will never taste food again, and lost sense of smell. Now, a judge just looking at the crime of assault and saying, yep, he punched him in the face and he broke his nose, would be like, okay, cool. Well, generally when someone assaults someone, I give them this sentence. It's a broken nose. There's not much to it. I'll give them this sentence. Having a victim impact statement allows this person to actually write or come into the courtroom and speak to the judge and say, hey, yeah, it was just a broken nose. But as a result of that broken nose, I had to have facial surgery to basically fix that up. And my nose doesn't work properly anymore. I can't taste food. I've lost my sense of smell. And I will never get that back. And that's going to affect me for the rest of my life. And all of a sudden, the judge might look at that and think, interesting. Rather than just giving them a 2-year sentence like I normally would, their act has impacted on this person for the rest of their life. I might jump it up to 3 years. So it allows the victim access and a platform to really outline how the crime has impacted their life, how it will affect them for perhaps the rest of their life if there's any ongoing harm, and then allow the judge to properly sentence the offender as a result. As I mentioned at the top, this doesn't really meet a skill. So there's no clear, explain, discuss skill listed in the study design for factors considered in sentencing. So we're going to assume it just comes under the 3.1.11, which is, if I remember correctly, synthesize and apply. Okay. So how that will actually look in terms of a question is, my best guess for what you can see on an exam or a SAC is going to be something like this. So you might have a bit more of a detailed case study. So this section here might actually be written up the top in, 2 to 3 paragraphs about what Antoinette did, and it would therefore lengthen out into a range of questions, 15 to 20 marks worth of questions. But we'll just consider it here as one isolated question. Antoinette is sentenced to a community corrections order for an assault. Explain why she may not have been imprisoned, and discuss the ability of a CCO, community corrections order, to meet the purposes of sanctions. So when we break down this question, we really need to look at the fact that, okay, there's 2 task words. Okay? So therefore, there's 2 aspects of this question that I really, really need to meet. And they are to explain something, and then I need to discuss something. Okay? So if we want to be smart, we break this question up into 2 parts. Now, in terms of how we work out how much time to devote to each of these, it's a little bit of an inexact science. But at the end of the day, this question's worth 5 marks. We know that discuss is a significantly higher or it's a higher order thinking skill, and it's more difficult to do than explain, and there's more detail you need to exchange opinions. So we can probably guess that our explain is worth 2 and our discuss is worth 3. Okay? So in terms of splitting up our work on this question and how we approach it, that's a breakdown we might take. So what are we explaining? We're explaining why she wasn't imprisoned. Okay, so she got a community corrections order instead of imprisonment, which means this is a reduction in sanction. Okay, so if we rewrite that out as a reduction in sanction, and then let's consider, just going back through the slides, we've just gone through those slides, what sort of things lead to a reduction in sentence? What sort of things lead to reduced blame? All of a sudden we know that, if we break this down further, that could be mitigating factors, or that could be guilty pleas. So our aim here to answer this question is, say if we went with guilty pleas particularly, why she might not have been imprisoned would be to identify guilty pleas and then explain why that leads to a reduction in sanction. Okay, so identify and explain. Then obviously there's the discuss element, which means meeting the purposes of sanctions. We just need to exchange opinions. Meets, doesn't. We know that it meets perhaps rehab, but it perhaps doesn't meet protection. And we're not going to spend a lot of time on that because we did that last video. So if you need more time on what purposes community corrections orders meets, head back to the last video. If we then look at a sample answer for this, what we've done here is I've broken it into clear paragraphs. This first paragraph addresses my explain task word, and then this second one addresses my discuss. Okay, so broken the question into two parts. You'd also note that this top section is probably about 2/3 of the length, maybe a little bit less of the bottom section, because as we said, that's probably worth 2 marks and that's probably worth 3. So I'm going to focus on the explain section because the explain section was why she might not have been imprisoned, which is why she might have had a reduction in sanction. Antoinette may not have been imprisoned as she may have pled guilty prior to trial. That is worth a mark because I have identified a reason why her sentence might have been reduced or her sanction might have been reduced. Okay, so I know what can lead to a reduction in sentence, bottom level of the pyramid, which means I've earned myself 1 mark. Now, to get myself a 2nd mark, I need to show that I understand what that means and why a guilty plea leads to a reduction in sentence. And that's what my second sentence does. Offenders who plead guilty may receive a reduced sanction due to saving the public money by avoiding a trial, as well as the fact that it shows remorse. Okay? So if you plead guilty, you may receive a reduced sanction because you've saved the public money, as well as the fact it shows remorse. Okay? Pretty simple, bang, 2 marks. This could have also read, Antoinette may have not have been imprisoned, as she may have had some mitigating factors. And then you would go on to explain what they could have been. Think about what would happen as well if this question was reworded. Antoinette is sentenced to imprisonment for assault. Explain why she may not have received a community corrections order. Okay? And there you'd be looking at, okay, she's gone to prison instead of a CCO. Why has she had an increase in sanction, aggravating factors, or victim impact statements? And then I've just discussed community corrections orders, which you can pause and have a look at if you like. They meet rehab. On the other hand, they don't meet protection. So just exchanging opinions on community corrections orders. As I said in the last couple of videos, we are going to look at the ability of sentencing and sanctions to meet the principles of justice as a whole. We're not going to break it down into the last 3 videos. So have a think about the purposes of sanctions, the types of sanctions, and factors considered in sanctioning. Think about where they might fit into here. Pause the video and do that now, and we are going to look at what I've included in 3, 2, 1. So, how do sentences, or how does sentencing achieve fairness? Well, mitigating factors take the personal circumstances of the offender into account. So this means that you are treated without bias and prejudice just because you might be homeless or you might be a drug addict or similar, and you are therefore treated with fairness in a just, impartial way. On the other hand, victim impact statements could be given too much weight. Okay? So if the judge really takes on an emotional victim impact statement, okay, and starts using that emotion in their sentencing instead of looking at facts, you might be treated with excess prejudice. Now, you might be treated as a horrible person when in reality you're only a mildly horrible person, if that's possible. In terms of equality, those 5 purposes of sanctions apply to all offenders and apply to all judges. So a judge can't just be like, oh, I'm a special case and I don't need to meet these aims of sanctions. They have to meet them too. In terms of equality, though, mitigating and aggravating factors mean offenders are treated differently in sentencing for the same crime. Someone who, like we saw, Antoinette was sent to or given a community corrections order for assault, someone else might be sent to prison. This means they're not being treated equally for committing the same crime, which could be seen as a lack of equality. There's also the idea that sentencing can be really inconsistent. Again, one judge might spend a lot of weight or spend a lot of time on victim impact statements and give a really serious sanction as a result, whilst another judge might kind of disregard those and focus on the mitigating factors. Judges are independent. They make their own sanctions. There are some guidelines from the government, obviously, but they get to choose sentences. It's a really important feature of our separation of powers. But this means that sentencing may be inconsistent, and we know inconsistency is unequal. Finally, in terms of access, one I just mentioned before was that victims being involved right through the sentencing process. So not only do we look at their rights in terms of to give evidence as a vulnerable witness during a trial and to be updated of proceedings, they also get to provide victim impact statements during sentencing, which shows that they have access to the criminal justice system throughout the entire criminal justice process. Therefore, victim impact statements promote access. So this is the skill I was talking about before in terms of applying to case studies, and there's a couple of really good ones for you to look at. I mentioned during the rights of the victim a podcast called The Law Report, and there was a video, a podcast on the rights of the victim where you heard from the wife of, it was Rodney Miller's wife, who was killed in the police shootings, Silken Miller, and you hear her talk about how, as a victim of crime, her husband was murdered, her rights in the sentencing process and those factors that were considered. So that's a really good one to listen to. The one I'm going to actually show you is the sentencing remarks for Martin Bryant. Now, if you are not aware, and hopefully you've heard of him, Martin Bryant was the man who killed 35 people at Port Arthur in Tasmania in 1997, I think it was, and led to Australia's changing gun laws. So he basically took a couple of semi-automatic rifles to this former convict colony, penal colony in Tasmania. It's a tourist attraction, and he, indiscriminately killed 35 people. He pled guilty to that. And there's a really, really interesting set of comments in his sentencing from the judge that we're going to just go and quickly have a look at. So I'll discard those. And they are these ones here that I have highlighted. So, the prisoner has shown no remorse for his actions. Though he has ultimately pleaded guilty, it has clearly been done in recognition of the undoubted strength of the evidence against him and amounts to little more than a case of bowing to the inevitable. That his change of plea, because he was originally pleading not guilty, has saved considerable distress, inconvenience and cost to those who would have had to have been called as witnesses, and to the victims and community at large by the prolongation, so increased length, of the proceedings is a factor which should be considered in his favour when weighing all the relevant conditions. But in the overall scheme of things, it is, in my view, overwhelmingly outweighed by the factors militating against him, so aggravating factors. So what the judges said here is that, hey, yes, this guy pled guilty, and it is worth considering from the sense of it did save distress, inconvenience, and cost. So that's important to consider. But on the other hand, he hasn't shown any remorse in pleading guilty. He's only done it because it's inevitable. And in the overall scheme of things, this goes no way to outweighing all of the aggravating factors against him. So things like the premeditation, things like the level of crime itself being murder of 35 people. With that in mind, and I'll link this in the notes below the episode, with this in mind, the judge goes on to explain that on each of the 35 counts of murder, that Martin Bryant would be sentenced to life imprisonment without parole, and he will never get out of prison. So doesn't matter that you pled guilty, we are not going to reduce your sentence. We'll head back into our factors considered in sentencing. And so as I said, we'll link that below, worth having a little bit of a read through if you want to see what the judge would consider. Obviously different jurisdiction, Tasmania, but yeah, judges all around the world have similar processes. So, in conclusion, what factors will a judge consider in sentencing? Make sure when you're answering this essential question, identify, but then also explain/expand, because you're going to need to know them in a little bit of detail to respond to case studies. This has been the Legal Studies Guy. Rate the video below or leave comments if you have any questions. You can email me at the Legal Studies Guy, all lowercase, at gmail.com, or obviously head to the Facebook page and rate that or leave some comments.